Case study.
Assalamualaikum. Today we are from Group 1. We discuss some questions from case study. Before that, I will introduce myself and our group members. My name is Nur Adina Ali Mete Abdul Aziz and my matric number is 049684 and my group member is Muhammad Naim bin Azmi 049632, Humaira binti Ahmad Irfan 049640, Nur Hassan binti Abdul Halim 050390, Vishalani Ganison 050534 and Silashini Sukumaran 049691. Firstly, I will brief the question. The client C is a local, privately owned limited liability manufacturing company in your country. Historically, the client traded successfully for several years and presently employs around 100 staff. The client is now experiencing major cash flow difficulty and expect that within the next month it will not be able to pay debts owed to a number of its creditors. Has those debts become due for payment and that its financial position will continue to deteriorate? Here's some questions that we discussed in our discussions. First, the business is basically sound, but accounting, financial and other advice is that before the client can return to a profitable position. So, what are the client requirements? Second, discuss whether the power of court to restrain proceeding of the company and list the relevant section. Third, discuss whether the limited liability company may be written up by court because the company deemed to be unable to pay its debt and state the section based by the scenario.
For this question, the client will require a general reduction of debt owed to all non-bank creditors, for example, a % of reduction, and an extension of the time for payment of the reduced debt, for example, in 12 months' time. Next.
Okay, next are scheduling of bank financing commitments. For example, deferring repayments of principal for 12 months and a reduction of interest payable. Other than that, some creditors are pressing for payment and are threatening to take enforcement action. In attempting to negotiate an arrangement as indicated above, the client will require protection. For example, a stay or suspension of all legal actions against the client and its assets. Lastly, the client now asks for your professional advice on the action it can take under the insolvency or reorganization laws to get to the stage at which a formal arrangement that embraces the above proposal will take effect.
For question 2, according to section 368, empowers the court to grant a restraining order to a company for a period of not more than 3 months, and the court may extend his period for not more than 9 months. If the court is satisfied that there is a proposal for a scheme of a compromise or arrangement between the company and its creditors, representing at least 1.5 in value of all the creditors. A restraining order can be a crucial tool to allow the distressed applicant company to have a moratorium from creditors' action and to allow for a successful restructuring of the company's debt through a scheme of arrangement.
Secondly, the solution for question 2 continues in section 368(1)(b). The court satisfied that the restraining order is necessary enable to the company and its creditors to formalize the scheme of compromise or arrangement for the approval of the creditors or members. From there, we can relate our case study into this section by the companies finds themselves into financial trouble because they are burdened with the large amount of debts. In such situations, there are 3 ways to come out by. Company can be wound up. The second, the receiver or manager can be appointed. Or the third, the company can go for the scheme of arrangement for the restructuring of the companies. Therefore, what means about the proposal scheme of arrangement, which means appointment of the scheme advisor tasked to evaluate the financial position and thereby to formulate the proposal which would provide a proposal which would deal with the outstanding debts of the company. Next, I pass the slide to Naim to present.
Assalamualaikum warahmatullahi wabarakatuh. Kemudian Zahra and Mr. I, Muhammad Ibn Azmi, with meeting number 049632. Today, I will proceed with the answer for the third question. The question is discuss whether the limited liability company may winding up by court because the company deemed to be unable to pay its debt and state the section based by the scenario. So first, this question means how can we know the company able to pay its debt or not? So let's proceed with the section. According to the Companies Act 2016, Section 467, where the winding up of a company will be deemed to have been initiated when a resolution has been confirmed by the company for voluntary winding up. Or in another case, the commencement of winding up shall be at the date of the winding up. In this case, the petition to wind up the company shall be filed within 6 months from the expiration date the notice of demand is issued. Next, there is the condition that can prove any company is though to be unable to pay their own debts. Firstly, the company is indebted in a sum that exceeding the amount as may be prescribed by the minister, and a creditor has served a notice of demand which required the company to pay the sum due by leaving the notice at the registered office of the company, and the company has a total of 21 days after the service of the demand neglected to pay the sum to the satisfaction of the creditor. Secondly, it is proved to the satisfaction of the court that the company is unable to pay its debt, and in order to determine whether the company is unable to settle its debt, it is very important for the court to take into account several things such as the liability of the company first before proven that the company itself cannot pay their debt. And lastly, execution issue on the basis of a judge decision or order of any decision in favor of the creditors of the company is returned dissatisfied in whole or in part. So that's all from me. Thank you.